Hello and welcome to week 11 of our 5PB webinars. We're pleased today to be joined by Rebecca Penfold from St John's Buildings, who in our second talk will, together with Dr. Aparna Rao, be discussing the right to protest in the age of coronavirus. Before that, Deanna Heer will discuss punishment or treatment, the sentencing of the mentally disordered. As always, please feel free to submit any questions using the question and answer function, and we'll seek to answer those questions we can at the end of both of the talks. For now, I'm pleased to hand over to Deanna Heer. Deanna.
Hi, I hope that you can all hear me, and hopefully with the assistance of Andrew, we're going to go through a PowerPoint presentation on sentencing people with mental health problems. And if we could go to the second slide, Andrew. Last year in July, the Sentencing Council closed a consultation for a new set of sentencing guidelines to assist courts to sentence those people who appear before them with mental disorders. So we are waiting for a Sentencing Council guideline on that topic. In the meantime, last year in the case of PS, the Court of Appeal, led by the Lord Chief Justice, handed down some guidance in conjoined appeals in which all the defendants had mental health problems. And in that case, the court gave guidance as to the relevance of mental health, the defendant's mental health, in the sentencing process. And they set out, and I'm going to take the first part of this quite quickly, that the defendant's mental health, as you might imagine, is relevant to his culpability at the time the offence was committed, and his mental health at the time of sentence is relevant to the type of sentence, which is what this talk will concentrate on, and obviously it's also relevant to the issues of dangerousness and to any conditions that were attached to community sentences, for example. Section 157 of the Criminal Justice Act of 2003 sets out that before imposing a custodial sentence, in any case where the offender is or appears to be mentally disordered, the court must obtain a medical report before sentencing, unless there are good reasons which make it unnecessary to do so, which might include, for example, that there is a pre-sentence report which covers the same ground. So really, if you are suspecting a client to be mentally disordered, whether that be a learning disability or something more serious, the court should be allowing you to get a report of some kind before the defendant is sentenced. We can go to the next slide, please. Just setting out here some areas where the courts have provided guidance. In the Overarching Principles, the new set of principles that were issued last year, the Sentencing Council set out a broad definition of mental disorder, which includes people with low IQ, cognitive impairments such as dyslexia or ADHD, people with autism or autism spectrum disorder, people with personality disorders, or in the case of young people, it's more likely to be referred to as a conduct disorder, and people with mental illness such as psychosis or even just depression. So the court setting out a wide range of circumstances where the mental health of the defendant should be taken into consideration. If you have the next slide, please. The Overarching Principles really set out what I've just been through, that the mental health of the defendant is relevant, usually in the specific offence guidelines at step 1 as a factor reducing culpability or as a mitigating feature further along the sentencing process. And if we can just skip to the next slide, please. In respect of young people, the Sentencing Council guidelines on sentencing children and young people address this issue at paragraph 1.12 and make it clear that the mental well-being of the defendant is something that the court should have regard to when considering its statutory obligation under Section 44 of the Children and Young Persons Act, to have regard in sentencing to the welfare of the child. So another way in which the Sentencing Council is highlighting the importance of this issue. You can go to the next slide, please. The specific sentencing guideline is expected sometime soon. Who knows now that we're deep in COVID-19, but watch this space. If the draft guideline is anything to go by, it will include a helpful sort of potted summary of the type of mental disorders that might be described in a medical report and what those mental disorders are and how they affect an individual. It also will go through the different types of sentence that are available and the factors to be taken into account when deciding which type of sentence should be imposed and its characteristics. So watch this space. If we go over to the next slide then, the meat of this talk really are the 4 sentencing options that I've set out on this slide. And I'm making direct reference really to sentences that are available under the Mental Health Act of 1983. And they are a Section 37 hospital order, a Section 41 restriction order, what's known as a hybrid order, which is Section 45A. Its proper title is a hospital and limitation direction. And then there is the administrative power of the Secretary of State to order that a prisoner be transferred to a hospital under Section 47. So if we go to the next slide, dealing first of all then with a Section 37 hospital order. It's only available to the court where the court is sentencing an offender for an offence where the sentence is not fixed by law. In other words, it's not available to somebody convicted of murder. And just to digress for a moment, if you do have a defendant who is to be sentenced for murder, look at Schedule 21 of the Criminal Justice Act, and in particular paragraph 11, which sets out the mitigating features. The mental disorder of a defendant is relevant to the court's consideration of the length of the minimum term if it lowers the degree of the defendant's culpability in the commission of the offence. And there's a case called Coonan, it's relatively old now, 2011, which makes it clear that although the mental disorder of a defendant might mitigate the sentence, it doesn't necessarily do so. And the degree to which it does, if it does at all, has to be assessed in the overall context of the case, including all the aggravating features. So if we can go to the next slide. And going back to Section 37 hospital orders, Section 37 also deals with guardianship orders, but I'm not going to cover those in this talk. The court will have to receive evidence from 2 registered medical practitioners. It doesn't have to be oral evidence, it can be written evidence. But Section 37 orders cannot be made unless the following criteria are satisfied. Firstly, that the defendant suffers from a mental disorder. And under the Mental Health Act, that's more narrowly defined in the Sentencing Council guidelines. Under Section 1, a mental disorder is any disorder or disability of the mind, except a learning disability, unless that learning disability is accompanied by abnormally aggressive behaviour or seriously irresponsible conduct. Secondly, the disorder has to be of a nature and a degree which makes it appropriate for the defendant to be detained in hospital. And finally, appropriate medical treatment is available. So those are the criteria that must be satisfied. But even where those criteria are satisfied, the court retains a discretion whether to make the order. And I've set out there at the bottom of the slide the test, which is that the court should have regard to all the circumstances of the case, including the nature of the offence, the character and the antecedents of the offender, and to the other available methods of dealing with him. And only if the court concludes that a hospital order is the most suitable method of disposing of the case should an order be made under section 37. You can go to the next slide. Where a hospital order is made, the court has the power to attach a section 41 restriction order. The section 41 restriction order is only available in the Crown Court, but in the Magistrates Court there is a power to commit under section 43 of the Act to the Crown Court if the court thinks that there should be a restriction order attached. The court has to hear oral evidence on this point from at least one of the registered medical practitioners and can attach a section 41 restriction order to a hospital order if it considers that it's necessary for the protection of the public from serious harm. Again, the court retains a discretion whether to make a restriction order, even where the medical evidence suggests that it's not required. And the authorities for that I've set out there are Royce and Birch. Birch is quite a useful case in setting out the different types of sentences available under the Mental Health Act. And the effect of a restriction order is to restrict the responsible clinician's ability to discharge or transfer or grant leave to a patient without the consent of the Secretary of State. And if we can then go to the next slide, please, Andrew. So the third option available to the court then is the section 45 hospital and limitation direction. Again, it's only available to a Crown Court judge, and only again where the sentence is not fixed by law, so not available in a case of murder. Where the criteria for a hospital order are satisfied, but the court decides to impose a sentence of imprisonment, it also then has the discretion to direct that, notwithstanding the prison sentence, the defendant should be detained in hospital to the same effect as section 37, with or without section 41 restrictions. It's useful and important to note that the section 45A order is not available to those under 21, because it only the legislation only refers to a sentence of imprisonment, and of course those under 21 are not sent to prison, so it's not available to anybody under that age. It seems to be nothing more than a drafting error which is yet to be corrected, but that's the current state of play. We go over the page then to the next slide. Dealing then finally with a section 47 transfer. So where a sentence of imprisonment has been imposed by the court, the Secretary of State nevertheless has the power to transfer a defendant to hospital where the section 37 criteria are satisfied and where it's in the public interest and expedient to do so. And if it becomes apparent that a defendant who is detained in prison should really be detained in hospital, the Secretary of State has to act as soon as he reasonably can to do that. Now, the administrative transfer, as this is sometimes called, applies to adults. It also applies to those under the age of 21, and it also applies where the sentence is fixed by law. And it can be accompanied by a section 49 order, which effectively imposes restrictions in the same way that section 41 does. So let's then go over to the next slide, and really the discussion that I hope we'll have later in this talk is really focused on how the court will exercise its discretion to impose a sentence under either Section 37, Section 37 and 41 combined, or whether it makes a hybrid order under Section 45A or just leaves it to the Secretary of State to sort out at a later time. Well, the key case that considered this was Vowles in 2015, when the emphasis apparently was on imposing a custodial sentence of some sort. And the court said in that case that the discretion of the court in deciding whether to impose a custodial sentence or a hospital order of some sort was not circumscribed by the psychiatric opinion. So even where the Section 37 conditions are met, the court still had to consider the appropriate disposal, having regard to, firstly, the extent to which the offender requires treatment, secondly, the extent to which the offender's offending is attributable to or caused by the mental disorder, as opposed to some other reason, the extent to which punishment is required, and importantly, the protection of the public, including the release regime, which is applicable to the different types of sentences. And the court said this: there must always be sound reasons for departing from the usual course of imposing a penal sentence, and the judge has to set out those reasons if he decides to depart from that usual course. So let's go over the page, if we can, to the next slide. The leading case now is the case of Edwards, decided in 2018, which set out, or which was decided in which it was decided, I should say, the court decided to give further guidance to address what it described as a level of misunderstanding of the guidance provided in Vowles, and made clear that the case of Vowles was not suggesting that Section 45A should be used to provide what was described as a default setting of imprisonment. It explained that the sound reasons referred to in Vowles may include the nature of the offence and the limited nature of any penal element if imposed, and the fact that the offending was very substantially, albeit not wholly, attributable to the offender's illness. However, it said the graver the offence and the greater the risk to the public upon release of the offender, the greater emphasis the judge had to place on the protection of the public and the release regime. In other words, there's a balance to be struck by the court in considering how much punishment is required and how much the public requires protection. So if we go over to the next slide then. The correct approach was set out by the court in the case of Edwards, at paragraph 34. And the court has to consider all these different questions in this order. Firstly, it has to consider whether a hospital order is appropriate at all. If it is, it then has to consider all the sentencing options that I've just been through with you, including Section 45A. And the judge, in making the decision about which sentence to impose, should remind him or herself of the importance of the penal element in the sentence. In other words, the importance of the need to punish. The assessment of that will require an assessment of the defendant's culpability as well as the harm caused by the offence. And importantly, the judge has to consider the applicable release regimes and again the protection of the public. It's worth noting that the Sentencing Council definitive guideline for manslaughter by diminished responsibility really mirrors the steps that are set out in Edwards, so it's quite a useful checklist to go through if you have a sentence of this nature. Can we go to the next slide, please? So the first question then, is a hospital order appropriate at all? Well, that requires a consideration of the nature of the mental disorder and the availability of appropriate treatment. Now, Voles made it clear that each case has to be considered on its own merits, but it also set out that as a general rule, a hospital order with restriction is more likely to be appropriate in a case where the mental disorder is a mental illness rather than a personality disorder. And that's because a mental illness is much more likely to have a direct bearing on the offender's culpability. So, for example, if the defendant is suffering from psychosis, more likely to affect his culpability and more likely to be responsive, I should say, to treatment in a hospital, whereas a person suffering from a personality disorder, which is likely to be much more long-standing, is less likely to be amenable to treatment in hospital, and the personality disorder is less likely to reduce the defendant's culpability for the commission of the offence. If we go to the next slide, the court went on that treatment in hospital for those with personality disorders should generally only be considered for those who also have a mental illness or brain damage. And that's because there's a risk that the defendant would become stuck in a hospital for a very long time without receiving appropriate treatment. And there's a risk in those circumstances that he or she could apply to the Mental Health Tribunal, now known as the First Tier Tribunal, to be discharged because appropriate treatment is not available, and because the court said that there is, for certain conditions, treatment available within the prison estate, and that includes psychological treatment, for example, at specialist units such as Wakefield Prison, which is accredited by the National Autistic Society. So a hospital order, even though somebody is being or suffering from a mental disorder, not necessarily the right disposal of the appropriate treatment is not available, and there will be no improvement. So we can go to the next slide. In Vowles, the court said that a Section 37 order accompanied by restrictions is likely to be the correct disposal where, firstly, the mental disorder is treatable. So if it can be treated by medication, such as antipsychotic medication, for example, where once treated, there's no evidence that the defendant would be dangerous, so low culpability, and where the offending is due to that mental disorder, again, low culpability. Next slide, please. The court has to consider then what the other options might be. And the court in Vowles set out some of the disadvantages of a custodial sentence under Section 45A, or a custodial sentence leaving it to the Secretary of State to decide on transfer. The disadvantage of a Section 45 order, the effect of which is that the defendant is detained in a hospital until he's well enough, but then instead of being discharged is remitted back to prison, may be that once returned to prison, the defendant is suffering from the kind of disorder that may mean that he stops taking his medication, and that's not an unusual outcome. And secondly, the release regimes are applicable. You've got to consider the kind of supervision that the defendant needs in the community following release. Conditions that are attached by the parole board are not necessarily more robust than the conditions that might be attached by the mental health tribunal to a hospital order. And if we can go to the next slide, please. Let's turn then to consideration of the need for punishment. This requires an assessment of the defendant's culpability, or what's sometimes referred to as his retained culpability. In other words, the degree of culpability that's attributable to the defendant rather than his mental disorder. In other words, the extent to which he might be bad rather than ill. And the court said in Vowles that a reduction in culpability, as I've said, is more difficult to attribute to a personality disorder than a mental illness. And in Westwood, where the defendant killed his mother in anger as a result of a psychotic episode, in that case, the Court of Appeal said that the judge had erred in focusing on the immediate cause of the killing, which was the defendant's loss of control because he'd lost his temper. And the court should have focused more on the underlying cause of his loss of temper, which was that he was in the throes of a psychotic episode, which caused him not to be able to control his temper. And as a result of that, it overturned the sentence that had been imposed. In Edwards, the court commented that whilst the failure to take medication was obviously relevant to the defendant's culpability, it's not necessarily a culpable omission. It might be because of the defendant's mental illness. If we go to the next slide then. So the type of factors that the court will need to take into consideration when deciding the defendant's retained culpability will be the degree to which his or her mental disorder affects his ability to make judgments or rational choices, affects his ability to understand the nature of what he's doing and the consequences of his actions, whether it causes him to be more disinhibited than he might normally be. Attempts to seek help before the commission of the offence would lower his culpability, whereas evidence of premeditation and planning or attempts to minimise his wrongdoing afterwards are likely to point towards an increased level of culpability. The court has to consider the degree of insight that the defendant has into his illness, and obviously there will be many cases where there are other contributory factors that the court has to take into consideration, such as alcohol abuse or the abuse of illicit drugs. And go to the next slide, please. The court also has to consider what punishment it's thinking about and the type of sentence, custodial sentence, that it's thinking of imposing, how long that custodial sentence might be. In Fisher, the court said that even if a fixed period of detention is considered appropriate in order to punish the defendant, if that period of detention is going to be less than the period required to treat the defendant, then a section 45A order loses its force entirely, because whichever route is taken, whether it's a hospital order or a custodial order with a direction for limited detention, then the offender is going to spend all that time in a hospital in any event. So consider what the length of the sentence is likely to be. If we go over the page to the next slide, in Westwood, the case I referred to a moment ago, the court had imposed an extended sentence of 21 years with a custodial term of 16 years. So the defendant was going to serve 8 years at that time before being eligible for release. Plus, there was a Section 45 order for detention in hospital and treatment. That was quashed and replaced just with a straight hospital order with restrictions, because it was concluded that the defendant required lifelong treatment. And the court had no confidence that by the expiry of the penal sentence, the defendant would have been successfully treated. And so the court considered what would have to happen in those circumstances. The defendant would have to be released or held just under a Section 37 order, and decided that the public wasn't being properly protected, even though the sentence had a custodial element built in. So that takes us then to a consideration in a bit more detail of the release regimes, which I hope will make some sense of what I've just been talking about. The release regimes vary according to the order which the court imposes. Under a straightforward hospital order under Section 37, the decision whether to release the defendant, or I should say discharge the hospital order, is the decision of the responsible clinician, who has to discharge the order if the medical conditions which justify the defendant's admission to hospital cease to be met. So in other words, if he's no longer suffering from a disorder, or no longer requires detention, or appropriate treatment is no longer available to him. And if the responsible clinician doesn't discharge him, the defendant can apply to the first tier tribunal for a discharge. And that can be done, I think, once in the first 12 months, between 6 months and 12 months, and then annually thereafter. If a Section 41 order is attached to the hospital order, then the responsible clinician can't act without the consent of the Secretary of State, or the Secretary of State can act on his own, or again, the defendant can make an application to the first tier tribunal. And if we go over the page, the first tier tribunal must direct an absolute discharge if it's not satisfied that the defendant is suffering from a mental disorder, which makes it appropriate to be detained in hospital for treatment. If it's not satisfied that it's necessary for either for the health and safety of the defendant or the protection of others that he should receive treatment, or it's not satisfied that appropriate treatment is available. And it's not appropriate for the defendant to remain liable to recall. If he is to remain liable to recall, then the first tier tribunal can conditionally discharge the patient. Go over to the next page. So whereas the Section 37, Section 41 decision to discharge the order is very much based on the medical health, the mental health of the defendant, under Section 45A, there's more flexibility because Section 45A order allows the defendant, if his mental health improves during the term of the custodial sentence, the custodial term, in other words, before his automatic release date, then the Secretary of State, rather than allowing him to be released into the community, can send him back to prison to serve the remainder of his sentence by way of punishment. And then he would be subject to, if it's a determinate sentence, the usual release provisions. If it's an indeterminate sentence, then it's going to be a matter for the parole board to decide whether he can be released. And if we go over the page again, just for the sake of completeness, Section 47, this applies where the court has decided that there must be a term of imprisonment or detention. The Secretary of State then decides to transfer the defendant to hospital. If he makes an order under section 47 alone, while the effect is the same as section 37, the defendant could be released according to the opinion of the responsible clinician alone, but that would be a rare order for the Secretary of State to make. He almost invariably will attach section 49 restrictions unless the defendant was about to be released from prison when he made the order. If a section 45 restriction is attached, then again the Secretary of State ultimately decides whether the defendant should be discharged from hospital into the community or remitted to prison. And if he's remitted to prison on an indeterminate sentence, then it will be for the parole board to decide whether the defendant can be released. And the parole board will take a wider view of public safety and will only release the defendant if it's satisfied that it's no longer necessary for the protection of the public that he should be confined. So ultimately, if we go over to the final slide, then the choice is between release determined by the first tier tribunal, where the focus is on the defendant's mental health and treatment, or release at the direction of the parole board, where wider public protection considerations apply. And that's more likely to be the case where the defendant is suffering from a condition which is not easily treatable, which is unlikely to improve with treatment in hospital, and where it's less likely that the court will decide that the defendant's responsibility for the offence is a result of his mental disorder rather than his own decision and actions to commit the offence. So that's the conclusion. Andrew, I don't know whether you want to take back control, as they say.
Thank you very much, Deanna. I'm always happy to take control.